This is the Economic Club of Florida, a distinguished platform for discussion of the major national issues of the day. On today's program, Florida Supreme Court Chief Justice Charles Canady on efforts to reduce the court system's previous 600,000 case backlog from the pandemic.
Some dockets have not done as well as others. We've got some problems on some of the dockets. But on the circuit civil and the county civil, the dockets where we impose the aggressive case management requirements, we've had dramatic reductions in the backlog.
Good day and welcome to the 557th in our series of distinguished speaker programs. I'm Harvey Bennett for the Economic Club of Florida. We're very honored to have with us today the Chief Justice of the Florida Supreme Court, Justice Charles Canady. Justice Canady has served on the state Supreme Court since 2008. He's in his third separate term serving as Chief Justice. Chief Justice, welcome. Our members have certainly been looking forward to this.
Thank you very much. I'm delighted to be with you today.
Our Florida courts, of course, administer the laws and dole out justice in both criminal and civil cases, but there's an often overlooked impact the courts have as a result on our daily commerce and thus our state economy, right?
That's absolutely right. Having a strong court system is key to the rule of law. And having the rule of law is essential to our prosperity. When people in business have disputes, they need a peaceful way of expeditiously resolving those disputes. And having a court system where contracts are enforced and you have predictability for commercial transactions is absolutely critical to a healthy business environment.
Now, one of the topics you're going to talk about with the club today is how the Florida court system is managing its cases and its work during the coronavirus pandemic. How is that going?
Well, we have made a lot of progress. Of course, we're essentially now back to normal operations after an extended period where we could not be operating normally. But we developed a serious backlog during that period, but we've had a great deal of success in reducing that backlog in recent months.
And of course, the criminal cases have to come before the civil.
Well, and the criminal cases are particularly challenging, but we're making progress there as well as on the civil side, and so we're encouraged. There's work left to be done, and this was an enormous disruption in the life of our court system, but we kept the wheels of justice moving, and we are continuing to make progress in dealing with the backlog.
You've served on the Florida Supreme Court for nearly 14 years. What's one thing about the courts that people may not realize?
I think one thing that some people may not realize is that our court is a court of limited jurisdiction. We're unlike many other state Supreme Courts, which basically can take any case from a lower court in that state that they wish to review that's brought to them. We can't do that. There are certain categories of cases over which we have jurisdiction. If it doesn't fall in one of those categories, we can't take it. The truth is, in Florida, the court of last resort for most cases will be the District Court of Appeal.
Gotcha. Chief Justice Charles Canady, thank you, sir. We look forward to hearing your formal address on Florida courts by the numbers.
Thank you very much.
Now, here's retired Florida Supreme Court Justice Major Harding, former club chairman and now ex officio member of the club's board of directors, with our formal introduction.
It's a privilege and an honor for me to introduce our speaker today. Justice Canady was born in Lakeland, Florida. He's married to Jennifer, and they have 2 children. He received his bachelor's degree from Haverford College in Pennsylvania and his law degree from Yale Law School. He went back to Lakeland and practiced law there from 1979 to 1992. But during that time, he served 3 terms of the Florida Supreme Court, and then later 4 terms on the United States House of Representatives. Throughout his service in Congress, Justice Canady was a member of the House Judiciary Committee, and for 3 terms, he was chairman of the House Judiciary Subcommittee on the Constitution. Upon leaving Congress, Justice Canady became general counsel to Governor Bush, and he was later appointed by Governor Bush to the Second District Court of Appeal and in 2002. In 2008, Justice Canady was appointed to the Florida Supreme Court by Governor Christ, and he took office in September of 2008. He is the 54th Chief Justice of the Supreme Court of Florida. But most significant, I think he has served in positions of leadership in all three of the constitutional branches of our government. And it is my honor and privilege to introduce and call to the podium Chief Justice Charles Canady.
Thank you. Thank you, Major. I appreciate the very kind introduction. I did not know I was number 54, I have to confess. And I will remember it because I was born in 1954, so that's a convenient happenstance. But I do appreciate the opportunity to be with you all here today. I'm delighted to be with all these lawyers here at the head table, although I think I'm happier to be with the non-lawyers here. I'm usually just with lawyers, but it's great to be in the community and to have this opportunity to be with you today and to talk to you about our legislative branch. Some of this will be kind of old hat for the lawyers and particularly the judges, but I'm hopeful that this will be interesting particularly for those of you who might not be as familiar with the judicial branch. Many years ago, Daniel Webster was arguing a case about Dartmouth College before the Supreme Court, and he said, it is a small school, but there are those who love it. Well, our judicial branch is really a small branch, but it's a very important branch, and those who are involved in it love it, and I think the people who are served by it, many of them love it, and it's important to the life of our state. What I want to do is give you an overview by the numbers of the Florida judicial branch, and then I want to talk specifically about the numbers related to and some other things related to our operations during the pandemic. Now, for the 22 million people in Florida, we have a judiciary made up of around 1,000 judges, okay, from top to bottom. We've got we have 935 trial court judges. 605 of those are circuit court judges, which is our court of general jurisdiction, the trial level. 330 are county court judges, which is the small claims, misdemeanors. It's kind of the cases below the level of the circuit court. We have 64 district court judges on 5 districts around the state, and we have 7 Supreme Court justices. So that is the judicial branch. And of course, we've got a wonderful group of people who support us, our staff, who help us administer the branch, without whom we could not do the work that we do as judges. Now, our system is a lean system when we compare it to other states. We have the 5th lowest number of trial court judges per capita. Okay, so we're right down there at the bottom among the states based on per capita trial judges per capita. Put it in context a little bit, Texas has more than twice the number of judges on a per capita basis. Now, obviously, there's a larger population, so they've got about 3,300 judges total. But you can see, if you look at those numbers, they've got more significantly more per capita than we do. Now, I'm going to talk a little bit about our state court funding, and I'm going to talk about funding for 21-22, because although the 22-23 Appropriations Act has been passed, it's not through the governor yet. So I don't want to, that depends on what the governor does with it. So I want to talk about the numbers for the current fiscal year, not the upcoming fiscal year. The judicial branch receives 0.7% of the state funding. Okay? Now, that surprises people when I tell people that, but it's still a lot of money because we've got a budget of around $667 million, which is out of the more than $101 billion state budget. Now, I put a little asterisk here when I talk about the 0.7% and these numbers. These are the monies that are appropriated to the state court system by the legislature. The operations of the state courts at the trial level are also supported by funds that go to the clerks of court. Now, they're not really part of the state court system. They serve the state court system, but they are constitutional officers who are elected, and they have funding that comes from different sources, primarily filing fees. But they support our operations. Also, the counties support our operations through the provision of facilities for the local courts, as well as certain funds for technology. So that's the bigger picture. It's a kind of a complicated funding thing, although overwhelmingly the bulk of the money comes from the state. All right. Let me move on to tell you a little bit about give you a kind of a taste for the magnitude of the work that is done in our system. And I'm going to use numbers here that are pre-pandemic numbers, which are kind of like, because obviously our numbers are affected by the pandemic, as we're going to discuss. But so I'm going to use numbers for fiscal year 2018-2019. In that fiscal year, around 3.6 million cases were filed in the trials courts. Okay, that's a lot. Most of those were in the county courts, but 700,000 of those cases were in circuit court. And so a total of 3.6 million cases. In our district courts, which are the appellate courts, the 5 appellate courts around the state, there were more than 20,000 cases filed. And in the Supreme Court, now our numbers, we calculate our numbers based on a calendar year as opposed to a fiscal year. But for the 2019 calendar year, we had nearly 2,200 cases. Now, I will point out, and I was talking about this with someone earlier. In Florida, our appellate courts, our district courts, are for most cases the court of last resort. The Supreme Court of Florida actually has limited jurisdiction. There are only certain categories of cases that we can take. Well, we're unlike most other state Supreme Courts who have a broader jurisdiction to take whatever case that's brought to them that they want to take. We've got to fit it within a particular category. I'm not going to talk about that too much, but that's an important thing to know about our system. So that gives you kind of an idea about the magnitude of the work going on in the branch. Of course, it's not surprising in a state of 22 million people that there'd be a lot of legal disputes, a lot of cases going to court. So those are the numbers on our filings. I now want to talk a little bit about how we managed the Florida courts during the pandemic. And when I talk about this, I'm always feel a little reluctant because I realize that the difficulties we had in managing the court system are similar to difficulties everybody had in managing whatever business they had or whatever entity they were responsible for. It's a challenging time for everyone. But one of the particular challenges that we faced in our court system is that, and particularly in our trial courts, is that historically, to do our work, we depend on gathering large groups of people together. Okay? We call large pools of jurors that have to come down to court. We have, and they're there cheek by jowl. Okay? It's like you can't. It's hard to adapt that sort of environment to the demands of the pandemic. And of course, that was one of the big challenges we faced in continuing our operations. So at the beginning of the pandemic, when we saw what was coming, and all of us were seeing it about the same time, because some of these orders that I'm going to talk about that I entered They were closing the schools on the same day. They were announcing it. The executive branch was announcing that and other steps. So this was all kind of coming at us, as you can remember. It seems like 20 years ago. It was just a little more than 2 years ago when it was all kind of coming at us. Now, there are two things that we had foremost in our minds when we confronted the challenge of managing the court system during the pandemic. The first was the imperative to not place court participants into unsafe situations. I mean, we had a responsibility. That is particularly, and I was particularly keenly aware of that because of the fact that we issue people invitations that they can't refuse. Okay? We say, you will show up. You must show up. And in some cases, if you don't show up, we will send the sheriff to get you. And so that's a little different than actually most other contexts where people, if you don't want to go to the grocery store, you want to do some other way to do it, you can do that. Or if you can use a service to deliver to you. But we require people to come to court. So we were very sensitive to that. But we also bore in mind the imperative to keep the work of justice moving to the maximum extent possible. You can't just shut down the courts. Now, I want to be very clear. I've talked to people over the course of the last couple of years who thought that the courts were closed. Our courts were never closed. Now, our operations were limited in important ways, but we were never closed, not for a minute. Now, some facilities were not open, but there was work going on in the courts, notwithstanding the limitations on access. So it was critical that we figure out a way to keep going to the maximum extent possible. And we did that. Now, the management of the pandemic was a work in progress. The management of our operations during the pandemic was clearly a work in progress. There were I issued 28 pandemic administrative orders, and there were 33 amendments to those orders. Now, don't worry, I'm not going to go through all those right here, so you can rest assured. So obviously, there were things that when we started out, we did not know how long it was going to be. We did not know everything that we were going to need to do. And so we're learning things as we went along and having to adapt, and other problems are brought to our attention that we needed to address. And so we were doing that on an ongoing basis. Now, early in this whole process, on March 13th of 2020, the Supreme Court granted the Chief Justice additional authority under the Rules of Judicial Administration to deal with the pandemic emergency. Basically, additional, more expansive authority to suspend and modify rules of court. Now, we don't modify statutes. That's not within our purview. Okay, but we can. The rules of court are within our purview. We have that constitutional authority, and the court granted the Chief Justice the authority to do that. And so all these orders are done under that authority throughout the pandemic. And we're used to dealing with certain types of emergencies. We're used to dealing with hurricanes. Obviously, that's an ongoing thing in Florida. And so we're used to courts having to be, court facilities to be closed and accommodating all the things that are associated with that. But what hit us with this pandemic, obviously, like everybody else, this was something beyond what we had ever experienced, at least anyone currently alive had ever experienced. So it was an ongoing process. So the first thing that we did was to suspend jury proceedings and to suspend criminal and juvenile speedy trial procedures. I entered an order on March 13th. The same day the court gave me additional authority, I entered that order. Again, that's the same day they entered the order to close the schools. And so it was weighing very, as that week began, it was weighing very heavily on my mind that we're summoning jurors now, and under our authority, jurors are being summoned, and it was becoming increasingly clear to me this is problematic. We're making people come in an environment where they might get COVID, and because there's a lot of things going on, but so I suspended jury proceedings at that point. We had also, at the same time, in that same order, I authorized remote proceedings. Now, jury trials, we really didn't have success conducting jury trials. That's complicated to try to do that remotely. There are all kind of issues, legal issues and other things swirling around that. But there's a lot that goes on in court that's not in jury trials. Okay, a lot of things happen in court. So we pivoted very quickly to the use of remote proceedings, and those were authorized beyond what was authorized in our existing rule framework on March 13th. And very quickly, we acquired for people throughout the judicial branch Zoom licenses. We used other remote platforms. I think that's the most common. We used certain other remote platforms, but most commonly in the branch it was Zoom. And of course, we'd never heard of Zoom. How many here had heard of Zoom before the pandemic? I mean, well, there's one person back there. Okay, I'm going to hire you for tech or whatever, a consultant. But we adapted, and of course, the appellate courts were able to essentially keep going without missing a beat. We did miss one oral argument session at our court because I think some people thought it was going to be over and we'd get back to normal. Well, I did not know it was going to last as long as it did, but I didn't think it was going to be over real soon. Okay, but the appellate courts found that we could conduct our oral arguments using Zoom, and it's not ideal. I think most of us prefer to do the arguments in person. I mean, I know I was really happy when I got back to being in the courtroom for the arguments. But Zoom wasn't too bad. I mean, the parties, the lawyers could make their arguments, and we never had any big problems with the use of that remote platform for our oral arguments. Occasional little technical glitch, but not much. So that worked. The trial courts also moved to using the remote technology for a lot of things, and it was a very dramatic. Now, again, as with anything, some judges were a little quicker than others to adapt to it, and some people, that's just kind of, down in Polk County, I was talking to the chief judge down there early on, and she said, well, we've got a few stragglers, and you're always going to have a few stragglers. But overwhelmingly, the judges figured that out quickly, and our tech people were absolutely marvelous in helping us do the things that we needed to do for that to work. And again, the lawyers adapted quickly because it was a challenge for them too, and it was something that many of them weren't used to. So so remote proceedings became a part of our life for a good part of the duration, and continue to be a part of our life. Early on in the pandemic, on April 21, 2020, I created the work group on continuity of court operations because, on the advice of my state court administrator, we felt that we needed to pull together a group of people from all parts of the court system, county judges, circuit judges, district judges, as well as members of the legal profession. We had also a public defender, a state attorney. We ultimately had a sheriff on there, all the kind of stakeholders, so we could figure out the best way to operate. And so that group was extraordinarily valuable. To try to do that just using the staff within our administrative structure and me, that would not have been good. I mean, I needed advice from people who were used to the kind of day-to-day operations. Of course, we had chief judges. And I'll let you say this, a big part of the challenge of managing things day-to-day in the pandemic fell on the chief judges of our various courts. who I think did a wonderful job. But so we created that work group, and they advised, gave me recommendations for various measures I adopted. Now, of course, we have continued to work using the remote technology. Some of those orders are still in effect that allow the use of remote technology as we're dealing with the backlog, which I'm going to talk about. Now, one of the challenges that we faced, as I mentioned earlier, was the difficulty of conducting jury trial proceedings, because you've got to pull those people together, and it just presented great challenges, particularly when you're operating under public health directives that require social distancing and all of that. Given the space limitations, it was just extraordinarily difficult for us to make that happen. So we weren't able to conduct jury trials, essentially, for an extended period of time. Now, it is the case that most of the cases that go to our courts never go to a jury trial. They just don't. Most get resolved before they ever get to a jury. But for a lot of cases, there will not be resolution until a jury trial is looming. As someone has said, you can't get it resolved until the parties see the whites of the jurors' eyes. Okay? There's something about that concentrates the minds, and they say, okay, let's go ahead and get this resolved, because trials are unpredictable, and there's great expense in trials, and if you can get it resolved before it goes to trial, then that's probably going to be best for both sides. But without that, the threat of looming jury trials, cases just weren't being settled. I can't say that nothing was being settled, because we did resolve a lot of cases, even during the period when we were not conducting jury trials. In fiscal year 2021, trial courts actually resolved more than 2.7 million cases. So it's not like nothing was happening. Cases were being resolved. But a lot of cases couldn't be resolved because there was no ability to threaten a jury trial, okay? And obviously, there's some cases that are going to go to trial. They just are, because the parties are that far apart, whatever. So that was hampering the operation of our system, the inability to conduct the jury trials, hamper the operation of our system, and has resulted in the development of a significant backlog in our trial courts. Not in the appellate courts. Actually, our work kind of slowed down. The new cases being filed slowed down because things weren't coming out of the trial court the way they ordinarily would. So we're looking at this backlog in early 21. We're looking at the backlog. We know it's coming. Of course, we've known that from the beginning, that we're going to have a backlog. We're looking at that then, but if you remember, that's the time when people are getting vaccinated, okay? Some people got vaccinated a little at the end of 2020. But people are starting to get vaccinated, and it's rolling out, and then it becomes widely available. And pretty soon, I mean, as we go, by the time we got to June, anybody who wanted to be vaccinated probably had the opportunity to be vaccinated. And that's just the way it was rolling. And so, and you know, get the full vaccination, the two courses, the two doses. And so, at that point, we knew that was coming. I mean, we were optimistic that was coming, and of course, by the beginning, we knew the vaccines were coming, and so we knew that was going to change the dynamic. So on March 9th of 2021, I entered an order, a pretty dramatic order, requiring aggressive civil case management for our circuit civil and our county civil dockets. And basically, to oversimplify it, these orders were to require that in individual cases, the parties and the lawyers be told, get saddled up and ready to ride. You're going to have a trial date, and it's coming. Because we felt, and I felt, and I consulted with my colleagues on this, but that without something like that, this backlog would just stay. We would have a hard time working through it. We had to put some pressure, not just on the judges, but on the lawyers. And so that happened. I think it put a great deal of pressure on people, knowing that they're having to get all the preliminaries done because of these looming trial dates. And so but people did it. They got in, and they did the work that had to be done. It was a stressful time for our trial court judges, and a stressful time for the lawyers as well. And I'll give you some, in a minute, I'll tell you a little bit about the success we've had with that. But I'm really grateful to the lawyers and judges for the extraordinary efforts they have made to work down the backlog. Now, so in June, entered that civil case management requirements in March of 21. And then by June 21, we're really trying to put in place measures to just move us back toward more normal operations. And the rule of thumb I was trying to use is once everybody has an opportunity to be fully vaccinated, it's kind of like, okay, we've got to get back to normal. We had a little hiccup, as y'all may remember, with Delta, and I had to give some additional authority, which I had taken away from the chief judges, because what happened is there were a lot of cases where people were getting sick, and they found out they're sick in court, and then it just, somebody's at trial, they're sick, and then everybody's in isolation. And so we put in I gave the chief judges some additional authority to require masking, which had gone away. But then we worked through that. And then by November, I entered an order which basically prohibited requiring masking and physical distancing. Because my view was, you've got to get back to normal, except in circumstances like if the local government had a valid requirement, then we obviously will follow whatever that is. But absent something like that, the judicial branch itself was not going to require people to mask. Now, we certainly allow people to mask. And candidly, there were times when I wore a mask even after I had, at our court, after June, we had no required masking. I wore it for a particular reason because of my own evaluation of my own risk, but we did not require it. And so since June, with some fits and starts, we basically moved back to full operation. Now, of the backlog of more than 600,000 cases, it's an estimate, but when we say a backlog, what we mean is cases that are pending on our docket above the number of cases we would have anticipated but for the pandemic, okay? So we extrapolate what we think would have been there, and then we've got X number more. And the X was 600,000, which is a lot. And that was the end of last June. We had that size backlog. Now, since then, we have been successful in an overall reduction of the backlog by 30%. There's some parts of some dockets have not done as well as others. We've got some problems on some of the dockets. But on the circuit civil and the county civil, the dockets where we impose the aggressive case management requirements, we've had dramatic reductions in the backlog. Circuit civil is down by 54%, county civil by 55%, which tells me that aggressive case management works. It's challenging, but it does work. And it really has exceeded my expectations. Now, I will say that that's probably, we've gotten the low-hanging fruit. It will get more difficult. The cases, a lot of those cases are cases that were settled, and we're going to get to the point where the cases that are left are cases that don't have to go to trial. And we've got limited, even when we're back fully operational, we've got limited capacity to try cases. I mean, only so many courtrooms, so many judges to actually try the cases. So it'll take us a while to work through that. But I think because of the aggressive case management, we were able to really shrink that number beyond what any of us would have anticipated. And again, that's due to the hard work of lawyers and the trial judges who have been doing that. And so I want to express my gratitude to all of them and to the chief judges, Judge Rowe, the other chief judges in our system who have really done outstanding work in helping manage the branch. And now, before I get the hook, I'm going to stop and open it up for questions, if that's appropriate.
So members can ask questions, please. The Chief Justice has said he would answer a few questions in the time allotted. And we have a microphone.
And I always have to give this caveat, and you've heard this before, I think. I'll be happy to answer absolutely any question you have, except any question about a pending or impending case or any controversial matter. Aside from that, have at it.
He gets to choose what the...
Okay. Okay. All right.
First off, thank you for being here, all the justices and major setting the precedent. SCOTUS and the Roe versus Wade, the whole issue of trust and that breach, that leak. From your perspective, leading our courts here, how important is that intangible trust among staff and your colleagues? And how does that work on a day-to-day basis?
Okay, you're talking about the leaked document. And that's a very serious matter. I mean, we take that very seriously. So far as I know, we've never had a breach of our court security. But it's absolutely essential that the deliberations of courts be confidential and not leaked. And if you think about it, and there are all sorts of contexts in which that just corrupts justice if it's leaked. So that's a very serious matter. I don't think there's any judge in the country who would say anything other than that. So it's really a sad thing. It's a very sad thing.
Bill.
Thank you again for being here. You mentioned that Florida is number 5 on the bottom in terms of judges. Are we adequately staffed? And if we're not, how should the funding be changed in order to be adequately staffed?
All right. I think we have a lean system, but I think there are different ways to evaluate it. And we actually have a complicated system by which we evaluate judicial need. And we certify judgeships. If we think there's an additional need for judgeships, we certify those to the legislature. The legislature ultimately determines. Sometimes we'll certify them, and they won't create the judgeships. Sometimes they create judgeships that we didn't certify. But for the most part, they have been very responsive, and the legislature, I think, takes very seriously the needs of the judicial branch. I don't think there's anything wrong with being a lean system. I mean, it's a small percentage of our budget, as I said, but it's real money, and it's taxpayer money, and we need to make sure we get the full, effective use of that money. We can always look at ways, and we have an ongoing process of looking at whether we're evaluating the need properly, and the court will continue to do that. But I think we've got a good, strong system. Could there be some improvement in some areas by increasing personnel? Yes. Part of the problem, and I should have mentioned this earlier, in dealing with the pandemic, the legislature actually gave us a significant amount of money for pandemic recovery because we realized of this backlog that we're going to have to deal with that. And part of that's judges, but part of it is also support staff and helping us organize that effort. Part of the problem, like the rest of the world, we've had trouble hiring people. We haven't been able to spend the money the legislature gave us because of the way the job market is. There are a lot of positions that are unfilled. But I hope that's responsive to your question.
I wasn't aware of that. The employment's open. Dave?
Justice Canady, thanks for being with us. It's good to see you. I've had the honor of being on the Bar Citizens Advisory Committee. And one of the things that we're trying to do is make use of more technology. And Canady Court has been pretty supportive of that. Do you think the Muniz Court is going to follow that? I mean, we've learned a lot about technology, the good and the bad of it in the last couple of years. If you look at the half full glass, the potential there is profound. And one of the things you learn is that you put the pressure on to get stuff done and get caught up. They have. They've done a remarkable job there. On 0.7% of our state budget for our court system is pretty remarkable. Some of us think that we could get the other 2 branches to work outside that's what we're But do you think going forward, technology will become a greater part of the court system?
Well, I think it's clear that technology's obviously, it's been a part of our life and it's going to continue to be. We actually have a rules case pending about the use of remote technology going forward, because a lot of what's going on now is going on under my emergency orders. I can't comment on that rules case. It's pending in the court. But so I can't really comment on that. But I think, you can just look at the world and you understand, I think regardless of what the court does in the rules case, lawyers are going to be using technology in a way they didn't before. I think some clients who previously wanted those in-person meetings will now say, Zoom's fine and it's cheaper. And so I think that's just part of the reality.
Question that you mentioned about the backlog of cases. We've all seen the recent tragedies ongoing with the active shooter situation, most of them involving mentally unstable persons. Florida has a at-risk law intended to respond to these situations with the number of backlogs that you had referenced in the court system. How do you see the court system responding in these situations where there's mentally unstable persons and their access?
Well, I think they call that red flag law. Those obviously get priority. I mean, those kind of things will get to the top of the queue because they're time sensitive. And there's a whole process set up for that. That's triggered in Florida under our law. That's got to be triggered by law enforcement. Of course, there have to be judicial determinations made. But I have not heard of anywhere where those things are not being resolved when they're coming in, notwithstanding the backlog, because those are things that, there's some things that just have to rise to the top and have to be dealt with, and that would be in that category.
Any other questions? I'm surprised. Typically, the members are not so bashful, Judge.
You all are a very gentle crowd, but it was great to be with you. I appreciate this opportunity. Thank you very much.
You've been listening to Florida Supreme Court Chief Justice Charles Canady speaking before the Economic Club of Florida on May 17, 2022 in Tallahassee, Florida. For more information on the Florida Supreme Court, visit floridasupremecourt.org. The Economic Club of Florida promotes interest and enlightenment on important economic, political, and social issues of the day. To learn more, including how to become a member, visit our website at economic-club.com. This program was recorded at the Florida State University Alumni Center in Tallahassee, Florida.